et à toutes. Je déclare
Good afternoon, everyone. I declare the meeting open. Welcome to meeting number 126 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in the hybrid format pursuant to the standing orders. Pursuant to the order of reference of Monday, April 24, 2023, the committee is resuming its consideration of Bill C-27. And I'd like to remind those who are here in person to keep their earpieces far from the microphone and to please familiarize yourself with the guidelines written on the notice boards in front of you in order to ensure the health and safety of each and everyone, especially the interpreters. Thank you very much for your cooperation. Today, we have from the Department of Industry, Samir Shabra, Director General of Strategy, Innovation and Policy Sector, Runa Angus, Senior Director of Strategy and Innovation Policy. Thank you both for joining us once more to this at this meeting for the clause-by-clause study on Bill C-27. Before turning it over to Mr. Williams, who had the floor when we were discussing CPC 9, the sub amendment from Mr. Perkins, I'd like to turn it over to Mr. Garon, who would like to take a few moments to discuss the motion which he tabled on Monday. Mr. Garon? Thank you, Mr. Chair. I think most of us here were informed of the Glentel affair, where two giants of mobile plans in a co-enterprise, a co-venture, decided to secure monopoly in Loblaws. And I think within this context, it's important for the committee to reflect on this issue, the issue of competition and business models that could actually harm competition. We discussed the issue of grocery stores significantly, and I think this is the case for cell phone markets as well. And in this context, you all received the motion which I tabled on Monday, 27th, which is as follows. I have no intention of entering into debate today, which reads as follows. As far as the contract regarding the sales of devices of former Lola and the Quebecor Freedom Mobile and the business model of Glentel, and pursuant to Section 1082, that the committee summoned them to discuss these anti-competition maneuvers. Mr. Miko Bibik, Director General of Bell, Darren and Whistle, Director General of TELUS, Tonus Teffier, Director General of Rogers Communication Inc., Gillan Weston, Director General of Loblaw, Percat Belado, Director General of Quebecor Inc., and Mr. Matthew Baswell, Director of Competition at the Competition Office in Canada, and that the committee assigned 2 meetings to listen to these witnesses. Thank you, Mr. Chair. Thank you, Mr. Garon. I would like to acknowledge Mr. Turnbull. The motion was not tabled, just introduced, so the notice was already circulated. Mr. Turnbull?
Yeah, thanks, Chair. And sorry, can't be with you all today in person, but I had to join remotely. So, but I just wanted to say generally supportive of Mr. Garon's motion, and the topic I think is an important one. And perhaps we can study it. I mean, I certainly think all along we've said we would continue to work and prioritize C-27. I'm hoping that we can agree to. I know we're not debating it today, but I just wanted to signal to him that that we're supportive of studying this, but would prefer to do so after C-27 if possible. Thank you.
Merci, Monsieur Massé.
Thank you, Mr. Massé.
This, and I'll circulate. I've written the Privacy Commissioner with Jagmeet Singh, and the Competition Bureau Commissioner, and we have received at least acknowledgement that they have it and they're looking at the situation. They of course cannot. They don't act on political direction, but they have acknowledged that they have the request and that they know the issue. So I want to confirm that we can circulate that correspondence that I just received yesterday back from the Competition Commissioner.
Merci beaucoup, Monsieur Massé. Alors, ça nous,
Thank you, Mr. Massé. That brings us back to CPC 9 and C-27. Mr. William, we were discussing the sub-amendment from Mr. Perkins. Over to you, Mr. Perkins.
Mr. Chair, and welcome back to everyone keeping tabs on C-27. Certainly, this amendment, we're still, for those listening at home, we're still working on the amendment on private right of action, and amendment that we're looking at to reinstate at least one line of that. I just wanted to make a few points that I was trying to end with the last meeting. When we talk about why we believe that the power should be going to the Privacy Commissioner, and what private right of action actually means in terms of taking the tribunal away and giving that power to the Commissioner. I believe it means an increased accountability for organizations. A private right of action would create a direct legal route for individuals to seek remedies for privacy violations, therefore increasing accountability of organizations, which is really important when we look at the Privacy Commissioner having that power, but also the ability for those individuals who first probably going through the Privacy Commissioner first, that can take their own legal remedy with organizations that violate their privacy. We talk about resource allocation for the Privacy Commissioner and the fact that perhaps that Privacy Commissioner will be overburdened. We all know what's happening with the Information Commissioner right now, who's asked for extra funding, who is backlogged and not getting that funding from the government. Well, this would allow individuals to take legal action for privacy breaches and reduce the number of cases the Privacy Commissioner has, even though they should be getting more funding depending on their caseload. We talk about there's a deterrent effect. The possibility of facing private lawsuits would act as a deterrent for organizations considering lax data protection practices. So the ability to have this through the Privacy Commissioner, of course, would be a deterrent. Empowerment of individuals. We've talked about making sure that privacy is a fundamental right. When you give this power to individuals, you're empowering individuals to take action and control of their privacy rights, which I think is a very important part of this bill. We perhaps could have a faster resolution of complaints compared to administrative processes handled only or solely by the Privacy Commissioner's office or by the tribunal. We think that this will be an enhanced privacy awareness as individuals take legal action, raises public awareness about privacy rights and the importance of data protection. So the more that gets into the hands of those individuals. This could be a reduction in systemic violations. The threat of legal action from multiple individuals could encourage organizations to implement more robust privacy practices, reducing the likelihood of systemic privacy violations and reducing the overall burden on the Privacy Commissioner. And it goes on, but I think moreover than that, it's a complementary role. Private right to action serves as a complementary mechanism to the Privacy Commissioner's oversight, ensuring a more comprehensive and multifaceted approach to privacy protection. And I think when we're looking at this, I think we all agree that this should be going first to the Privacy Commissioner, that the Privacy Commissioner should be the first step, but that private right of action is really important. Giving that power to the Privacy Commissioner so they can handle it, administer fines, still have the option of the courts, and then we find that the tribunal would be then unneeded. And I'll leave it at that, Mr. Chair.
Thank you, Mr. Williams. Do I have any other speakers? Mr. Viss, were you on the list? Yes, Mr. Viss then, and Mr. Massé.
In his testimony, Mr. Geist talked about whether a tribunal of this sorts would be respected. And he, just for clarification, he said there was a lot of public skepticism after the Roger Shaw deal. And just to clarify, because the amendment we have before us today will ultimately impact, if this will ultimately impact other parts of this legislation or this bill, and just for clarification, if a tribunal heard a case and then it had to go to court, would the court start de novo on the issue at hand?
Thank you very much for the question. The way the CPPA is structured now, a tribunal's finding would be considered firm and final and could not be appealed to a court. It would only be subject to a judicial review, which, as we discussed last meeting, is a much different standard and could only be reviewed on the basis of essentially the tribunal acting in a manner that was outside of its mandate.
During her testimony, Diane McLeod spoke about the complexity this will provide for provincial jurisdictions in respect to joint investigations with British Columbia, Ontario, and Alberta specifically. What does the department say in response to Mrs. McLeod's testimony that I'm sure you're aware of, and I think is a very valid point?
Thanks again for the question. As we've discussed over the last couple of meetings, there would be no impact on the investigatory functions of the Office of the Privacy Commissioner as a result of having a tribunal available. The tribunal would play two main functions, as we've discussed recently. One would be to make decisions about administrative monetary penalties that would be recommended by the Office of the Privacy Commissioner. And the second would be to form a body to hear appeals of those decisions. It would have no impact whatsoever, as far as we're concerned, on the ability of the Privacy Commissioner to enter into joint investigations, to develop investigatory approaches with provinces, to share data and findings. And in fact, in many places throughout the CPPA, we've tried to take pains to ensure that there are opportunities made available for data and information sharing on the basis of the Privacy Commissioner, working with other regulatory officers, including the Competition Commissioner and others.
Given that I believe Ms. McLeod represents the Privacy Office in Alberta, would the department at least acknowledge that the provincial commissions have a different view right now than the Department of Industry in respect to joint investigations, despite the assurances you're providing? Is that fair?
I'll ask my colleague, Ms. Angus, to provide a bit more detail on that point.
So I just want to clarify Ms. Diane McLeod's testimony. She did say, and I quote, "Our informal case resolution team operates separately from our adjudication team. When a file moves to inquiry, our adjudicators conduct a de novo hearing." So what I want to say in Alberta is that there is this separation between the adjudicative and the investigative function that is just not there in the CPPA, the way it's currently structured, and that's not bought in by the amendment.
Okay. Diane, Ms. McLeod also said, "We are concerned about whether the inclusion of the tribunal as an appeal body to the Privacy Commissioner's order would impact our ability to conduct and joint investigations." Will the department acknowledge that, as it is right now, the Privacy Commissioner of Alberta still has outstanding concerns about the ability of the Privacy Commissioner, in conjunction with the tribunal, if this legislation passes, to conduct joint investigations, and that there needs to be some work between Industry Canada and those respective provincial bodies to find a mutually agreeable approach if investigations are going to go forward in the future? Because what we heard, and we haven't heard anything different from the Privacy Commissioner of Alberta, is that right now their interpretation is different than yours.
Thank you for the question. I certainly am prepared to acknowledge that there are multiple perspectives and viewpoints that could be taken on this point. However, I think an informed reading of the proposed bill that's been put before this committee for consideration would make it very clear that there are no impacts on partnership or joint investigation work. The role of the tribunal that's been put forward is circumscribed to very limited activities and are really designed to ensure that there is a procedural fairness, that there is impartiality in the system, which, as the committee would well understand, is a constitutional guarantee. As Ms. Angus just pointed out, even the Alberta system has a separation between the investigatory and adjudicative functions built into the system. And so for that reason, it's critical to ensure that as the Privacy Commissioner moves from an ombuds function and moves towards an actual regulator with teeth, let's call it, for lack of a better term, there needs to be an element of procedural fairness and impartiality built into that system. Failing that, there's an extremely high likelihood of overturning these decisions on the basis of constitutional grounds, a constitutional challenge, on the basis of a lack of impartiality on behalf of the OPC. And for that reason, actually instituting the tribunal is an important mechanism by which to reinforce and strengthen the OPC's ability. If we imagine a scenario where there were no tribunal, it's very, very likely that any finding of the OPC, any action of the OPC, including levying of an administrative monetary penalty, for example, could be overturned on constitutional grounds. And that would send us back to a situation where we're back to a toothless regulator, which I think is broadly understood to be a state of affairs that we're trying to move away from.
Thank you. I'm going to follow up with the Privacy Commissioner of Alberta. I want to hear further from them about their position on what was stated, but I take your comments in good faith.
May I just one further point on that?
Yeah, thank you.
If that's okay. I just want to point out a specific section of the Act in case it's helpful regarding your question. And that's Section 119, Sub 2, which allows the OPC to enter into agreements with the provinces.
Thank you so much. Dr. Skaza from the University of Ottawa in October spoke about the independence of the appointed tribunal. It's my understanding that there will be 6 members of the tribunal, correct? Or 5?
Thanks very much for the question. The tribunal, as established, or as proposed, excuse me, would have between 3 and 6 members in total. At least 3 of those members must have experience in the field of information and privacy law. They would be appointed by the GIC and also have the remuneration fixed by the GIC. The maximum term would be 5 years, and they could be reappointed for 1 or more terms not exceeding 3 years each. They could be full or part-time members. The chairperson would supervise the distribution and assignment of members to hear matters brought before the tribunal and could be heard by panels of those members as well if considered appropriate.
3 would have to be considered privacy experts, but would the other 3 be subject, possibly up to another 3 members of the tribunal, would they be subject to a GIC appointment, or would they be appointed directly by the Minister of Industry?
Thanks again for the question. All would need to be appointed by the GIC.
Okay.
I was just specifying that at least 3 members would need to have experience in the field of information and privacy law.
Okay. I will note for the record that Mr. Terrien did say that this tribunal would create delays. This is more of a comment, would be duplicative, and that there's no international precedent for this. Perhaps you can challenge Mr. Terrien's comments on the framework that the department is trying to establish in this legislation and whether there is, in fact, an international comparison we as MPs can draw upon for further review as we move forward with this.
Thank you very much again for the question. I'll begin and then perhaps ask Ms. Angus to add in as well. I believe over the last couple of meetings we've highlighted a number of other jurisdictions. In fact, I'd like to back up for a second and start by pointing out that it really depends on the specific question that we're asking. If we're asking about a question of do other jurisdictions separate the investigative and adjudicative functions, the answer to that is almost universally yes. Whether we're looking at the UK or Ireland, as we gave examples last time, or Australia or New Zealand or Singapore, almost all have a system or a mechanism in place to separate the investigative and adjudicative functions. In other words, avoiding a scenario in which you'd create a judge, jury, and executioner all in one office. In Ireland, as we mentioned previously, they're not, the privacy regulator is not able to levy penalties directly, can seek those from a court or appellate body. They actually have the highest level of fines levied under the GDPR, under the General Data Protection Regulations of the European Union. New Zealand, costs and damages may be awarded, but they have to go to a human rights tribunal to seek those. Singapore also has a separation. Like I could go on and on. France also has a 2-tier separation system. So it's very, very common, not just in Canada, but also internationally, to have some degree of separation between a body that conducts an investigation, develops findings, and a body that makes a final determination about a penalty, for example.
Would it be a fair description to note that the separation that you just outlined would normally, in many of those other jurisdictions, though, are contained within one body, but 2 separate entities whereas we're creating essentially two separate institutions. Is that a fair description?
Thanks very much. It's actually a little bit, there are scenarios in which they are in the same body, but expert tribunal models are used in the UK, Australia, New Zealand, Singapore. So there are again, a variety of approaches that are undertaken. And again, as we mentioned last meeting, there can be constitutional grounds for that. So attempting to just sort of pick out one feature and do a comparison can be a little bit tricky because it doesn't necessarily take in the full scope of understanding of the constitutional grounds upon which that framework is based. And so when we look at it, we tend to look at it in the whole and understand how it functions in its totality. But to your question, and to answer it as a straightforward way as I possibly can, it depends on the jurisdiction. Many have a separation between two bodies. Some have bodies that are unified but have separations or firewalls built into the organizations that separate investigation and adjudication. At the moment, the Privacy Commissioner does not have that separation built into its functions. Our analysis was that it would be very difficult to establish that inside the body of the Privacy Commissioner as it stands today, in part because of its responsibility for the Privacy Act as well. In other words, the Privacy Commissioner is not just responsible for PIPEDA or in the future for CPPA, but also for administering the Privacy Act. And there are more challenges associated with covering that off and then also having this separation built into the Privacy Commissioner itself.
Thank you. Just going back to the appointments, I do find it somewhat concerning, even though they are GIC, but we know how GIC appointments work in this country, that only 3 people would be needed to be experts on privacy. So that means up to 50% of the tribunal don't have to be experts. It could be Joe Blow off the street, theoretically, or someone close to whoever is in power at a certain time. Do you believe, or does the department understand that the way the GIC appointment process could work for the tribunal could lead to individuals being appointed that have no business being on a tribunal that could be responsible for levying significant fines to global corporations?
Thank you again for the question. I think it's important to point out that the GIC appointments process is a rigorous process. There are safeguards in place in terms of the approach that's taken, recognizing that there are also complementary skill sets and experiences that could actually help benefit a tribunal in coming to its conclusions. Individuals with deeper experience in other forms of law, in technology, with an engineering or software engineering background.
In an ideal world, that's the problem. That's in an ideal world. We know how GICs work in Parliament, and it's not as rigorous as unfortunately you describe it to be. But thank you. Finally, the recent budget, if this legislation passes in the next fiscal year, there is no major change to the Privacy Commissioner's budget. How do we intend for the Privacy Commissioner to take on all of these new roles in this legislation without an increase in the budget? There won't be the regulatory teeth that you just mentioned without the financial backing behind it. Why didn't the department make a recommendation to increase the funding for the Privacy Commissioner in anticipation of this legislation? And I will note that the Sustainable Development Technology Canada, which is under a stop work order from the minister, had billions of dollars allotted to it, even though they're not an operating body right now.
Thank you very much for the question. It's a really important one in terms of resourcing of the Privacy Commissioner. And in fact, the department did anticipate this need, and in fact, the government did anticipate this need, and in fact, took action early. In Budget 2023, the resources available to the Privacy Commissioner were increased substantially. I don't have the numbers in front of me, but I believe it was more than 20 million over 5 years, and that was done very much in anticipation of this work to come.
What's the Privacy Commissioner's current budget?
Apologies, I don't have that figure to hand. I can certainly bring that back for discussion.
So it's going from approximate, is this a fair assumption, from like 25 to 29 million dollars? 26 million to 30 million dollars over the next 5 years? Or is it going up from 26 to 30 and then subsequently to 34 the following year?
I'd be very pleased to come back to the committee with a written response on exactly how the funding flows are designed to function.
I will note that the Privacy Commissioner, when he appeared before our committee, asked to have his budget doubled. So the Privacy Commissioner would disagree with the department's understanding that he has in fact been given the resources he asked for. Thank you. That's all for now, Mr. Chair.
Merci beaucoup, Monsieur Massé.
Thank you, Mr. Massey.
I hear what's being said with the tribunal, but I really don't believe a black hole in the earth will open up and swallow us all through it if we don't create a tribunal. It's one that I've raised to the minister from day one with this legislation, and I understand like there is logic behind creating it. I mean, it's not like something that's not unworthy of looking at. Do we have a budget estimate even on the tribunal in staffing?
So just to be clear, the tribunal will be supported by the Administrative Tribunal Support Services Institution, which already supports about a dozen other tribunals. So it's not a question of creating a tribunal machinery from scratch. It's very much going to be supported by an organization that already exists and that already provides services to a number of administrative tribunals.
So it joins, I guess, a group of other I guess I'm not as familiar with this. I'm going to do Democrat, so we don't get appointed to GIC positions. So that's just the reality of how this place works. So where I'm at now, though, I think important because I've listened really carefully over, and I want to be open so other members of the committee figure out where we're going on this. For me, I've always, been open to considering the tribunal. And I haven't been presented a good enough case for it. I know that there are some benefits to it. There's no doubt of that. But I still believe, and I think if there's resources that are lacking, then they should go to the Privacy Commissioner, because I prefer building a model where the Privacy Commissioner has the first solid ground on this. And then following that, there's a process to go to the courts. And I've heard from even the past testimony that we've had, no matter what, we can always end up back in the courts no matter what. So for me, where I'm trying to work on things is, there's people can sue. So I disagree with, but anyway, I'll let my friend explain that later. But for me, at any point, where I'm looking for is a model, and why I'll support the amendment to abandon the tribunal as part of this legislation, but to build one where the Privacy Commissioner does the first right of action, investigation, and so forth. And then if there's a case beyond that somebody wants to bring to the court, they can do that. I don't believe in, at this point in time for this legislation, the tribunal's the right move. So I just want to make that clear for members there, because I have an upcoming sub-amendment to adjust that part of the legislation that we have. Thank you, Mr. Chair, and thank you to the witnesses.
Thank you, Mr. Massé. I have Mr. Turnbull, Mr. Van Bynen, and then Mr. Badaway. Mr. Turnbull.
Thanks, Chair, and thanks to our devoted witnesses for being here yet again for another great debate. And thanks for all of your testimony, which I think helps elevate our debate and certainly provide us with good perspective on the various topics that we're sort of diving into. This one is particularly, so I know that we're technically right now debating a sub-amendment that Mr. Perkins put forward to an amendment that was originally moved by Mr. Williams. I think Mr. Williams' amendment looked to remove all references to the tribunal from the legislation. And I believe that Mr. Perkins' sub-amendment was to try and almost doctor and put back in the private right to action. But then I think there's some talk about striking a portion of that, which perhaps was unintended, if I'm not mistaken. And Chair, maybe you could just review where we're at, because I don't want us to get lost. It seems like a lot of our debate seems to be relating back to the original amendment, and not necessarily focused on the sub-amendment. And I'd like to try and stay focused on dealing with one issue at a time, even though I get that the broader debate is on the tribunal as a whole. Could you just clarify that for me,
Yes,
Chair?
Mr. Turnbull, you're entirely correct on where we are.
Okay. So, and I believe last time we had talked about how that this creates kind of a bifurcation, that what Mr. Perkins had proposed essentially would create two potential pathways for individuals to pursue. One would be through the OPC, which I think was originally contemplated to be the main interpreter of this law, and then this would create another track essentially that someone would be able to go through the court system. And I hear the arguments that yes, some things could still end up in the court system. I get that, but I think having the OPC and the tribunal set up seemed to streamline a process where less would be needed to be heard before the courts. But I guess what I'm trying to come back to is I think there is some significant points that we heard on the concept of natural justice being so important to how this legislation was crafted. And I think that as a core set of principles, to me, seem to be at the heart of the debate that we're having with regard to both, and it's coming up with regard to the sub-amendment, but also with regard to the amendment. So I wanted to give Mr. Chabra perhaps a little bit more time to just go into the details of, again, my understanding of natural justice is that it's supposed to maintain public confidence in the legal system, that it is a set of principles where you're supposed to be able to the greatest degree possible, remove bias and have a right to a fair hearing. But there may be other pieces of it that he would like to highlight. Could you maybe speak to that? And it could be either one of you. So, Ms. Angus, if you would like to contribute too, that would be helpful. Thank you.
Thank you very much for the question. Perhaps I'll get started, and Ms. Angus can add in if she's got additional points to add. I think it's a really important point that you're raising, and it's one that we've been trying to elaborate for the committee's benefit over the last couple of meetings. Any institution of this nature, whether in Canada or in kind of comparable democracies abroad, would by design build in some procedural safeguards, impartiality, ensure that in Canada in particular that the constitutional requirement for a fair and impartial hearing has been met. In the case of CPC 9, which seeks to remove the tribunal in its entirety, you're left with a scenario in which the Office of the Privacy Commissioner would be first prioritizing the investigations, prioritizing what to go and investigate, then conducting the investigation, then taking decisions on the basis, and in this case, levying very significant administrative monetary penalties as contemplated under the CPPA. That approach, in our view, would open the OPC's findings and decisions to constitutional challenges in court. As we've previously highlighted, going to the court is a more costly, time-consuming exercise, and it would be a de novo proceeding where there would be no deference paid to the Commissioner's findings. In addition to that, the risk of having the constitutional challenge result in the case being dismissed is quite significant. And if that were to be the case, you'd be essentially back at square one where we are today, where you'd have a toothless regulator without the ability to effectively govern and kind of guide activities in the market from companies.
I'd just like to add one point, and that is what the courts themselves have said about administrative tribunals. My colleague discussed how the process for going to courts can be expensive and long, and I just want to say that the Supreme Court of Canada has also recognized that. And in Vavilov, which is sort of the seminal case with respect to administrative law, the Supreme Court has itself said that administrative dispute resolution processes are generally designed to be less cumbersome, less expensive, less formal, and less delayed than their judicial counterparts, but no less effective or credible. So this is the Supreme Court of Canada itself acknowledging that administrative tribunals allow access to justice in a way that's faster and cheaper than they themselves would be able to. So I think that that's an important point to make.
And that's again coming from the Supreme Court of Canada. You would think that that would carry some weight in terms of our debate if the Supreme Court of Canada itself recognizes the value of administrative dispute mechanisms like the tribunal, and that actually enhances. So does the tribunal really just enhance access to justice in a sense? I mean, is that a stretch, or am I reading into it too much, or is that really what we're sort of saying, is that it enhances due process, helps to remove or maintain impartiality or remove bias? Can you maybe speak to just I get that your argument hinges around, and I think this is part of the disagreement here in the debate that we're having, is that some are saying that this tribunal is going to add bureaucracy and delay things. And I think that that's the opposite of what I hear your expert testimony telling us, which is that it is not going to do that, that it's going to be less cumbersome, less expensive, and get to resolution faster. Is that so? Could you speak to whether this enhances due process and removes bias?
Thank you. Sure. There's a couple elements in your question that I think are worth unpacking. I think the first is to understand that the tribunal would only come into effect or be engaged in a case where an appeal was sought by an individual involved in the proceedings, and it is designed to provide that procedural fairness and that recourse mechanism in a way that is much more efficient than going to the courts. So it does both provide the procedural fairness aspect, as well as doing so in a manner that is more accessible, less costly, certainly less time consuming. When you recognize especially that the tribunal would have the ability to take final decisions that could only be judicially reviewed as opposed to being appealed themselves. If you compare that to a hypothetical case where it's going to the courts, you've got Court of Appeal, and Supreme Court all as potential bodies that would be engaged in a hearing and appeal, which, as we know, would take many, many, many years to resolve. That's why as the proceedings have continued here, we've tried to take pains to point out that, in fact, establishing the tribunal gives the OPC more power and more authority and more leeway, as well as more credibility, and certainly reduces or very, very much minimizes the risk of a privacy commissioner's finding being overturned as a result of a lack of impartiality in process. This isn't about any kind of accusation of bias on the part of any officer or office holder. This is really about respecting the Constitution and understanding that impartiality needs to be enforced, needs to be built in structurally, and that proceedings and procedures need to have that basis if they're going to be testable in court, if they're going to be sustainable in that environment. The commissioner today, as we pointed out before, plays an ombuds function, plays an education function, plays an advocacy function, an engagement function. These are all important elements of the way that the privacy commissioner is empowered to do his job and to fulfill the role. It's important to recognize that attempting to turn that into something much more adversarial is a significant challenge, as we pointed out earlier. If there were attempts made to adjust the office and to put in place safeguards within the organization, that could be quite challenging, given the privacy commissioner also has responsibility for enforcing the Privacy Act. And could also make it much more difficult for the commissioner to engage with companies, with Canadians, to play the advocacy and support an ombuds function that he already does play. Using the tribunal as the mechanism to hear appeals and to make final decisions with regard to administrative monetary penalties allows the commissioner to continue playing the important roles that he plays today. Also adds significant enforcement powers, as we've discussed before, including the order-making powers, which are very, very significant. And it's also important to note that the government amendments that have been tabled to this committee also would give the commissioner the ability to enter into compliance agreements, which would obviate the need to go to the tribunal at all. If the parties were so willing to engage on that compliance agreement, the commissioner would have the ability to negotiate not just fines, but also damages, which would, in fact, eliminate the need for somebody to take on a private right of action or take on a separate case civilly, because, in fact, they could be made whole through the compliance agreement process itself. So in a number of different ways, we've thought through very carefully how to create a system that is robust, that is efficient, that is effective, that meets the standards required for the decisions to be upheld by a court.
I would just add to my colleague's point that the OPC, in addition to the order-making powers, also has the ability to engage in alternate dispute resolution mechanisms, including mediation and conciliation. So that is another avenue that the OPC can use, and that obviates the need for a tribunal. For parties to go to a tribunal, the OPC has ample powers to resolve disputes before even going to the investigation stage, and in fact does. The OPC actually resolves about 70% of complaints through alternative dispute resolution mechanisms.
So so thank you for that. That was really helpful. And I even learned a couple of things that wasn't all that clear about prior to this. So thank you for your testimony. I think what I'm sort of stuck on here is the comment that you made about if what's being proposed in terms of the sub-amendment and amendment were to pass and remove the tribunal altogether, that essentially this opens up any of the OPC decisions to constitutional challenges. That seems like it could have a really, that could really erode public confidence in the OPC's decisions and findings. Would it not do that over time if that became a fairly regular occurrence? That to me, it would be very tough to maintain an OPC with the powers that are contemplated within this bill. Is that not the case?
Thank you very much for the question. I think the consequences can actually go farther than that, because if there is a challenge, a charter challenge or a constitutional challenge that the enforcement system as contemplated by CPC 9 does not meet the principles of natural justice, does not guarantee perception of free and independent hearing. The court may render certain parts of the enforcement inoperable. So there are certain, whatever the court thinks is unconstitutional will be rendered inoperable, which may mean that a lot of the new powers that we're giving to the OPC through the CPPA may be rendered inoperable, which then brings us pretty much to the current situation, which is an OPC that has an ombuds role, but doesn't have a lot of enforcement power, and it becomes a toothless regulator, as my colleague said. And that was the number one piece of feedback that we heard from stakeholders since 2018 when we've been consulting on this, that what we need is an OPC with more significant enforcement powers. That's what we've done through the CPPA. But of course, with more powers, there has to be a accessible mechanism for oversight. That's a constitutional, guarantee of respecting principles of natural justice. So the current version of the Act tries to balance all of those different considerations in a way that's accessible, that's flexible, and that improves outcomes for all Canadians.
Thank you for that. That sounds like it makes sense to me. So it sounds like removing the tribunal not only makes, any appeal process more costly, because it more time consuming, perhaps less effective, but it also then opens up the possibility for constitutional challenges, which may remove the teeth from the OPC. Those sound like pretty significant unintended consequences of simply saying, well, we don't like the tribunal. It seems overly bureaucratic or something. It's really tough, because I really, at this point, I think your testimony has provided such great detailed evidence why this is truly needed. But I don't sense that, at least in terms of my colleagues on the other side, that they're being swayed by the I think very good and in-depth arguments that are being made. One of the things that came up in some of the other aspects of this conversation, or other parts of it, were joint investigations or interjurisdictional um, um, collaborations, let's say, between the federal government or the federal OPC and the provinces and territories. And Mr. Chabra had mentioned 119.2, I think, about agreements with provinces and territories. Could you maybe go into that a little bit more, and just assure us that at some point in the bill that it's sort of allowed for and contemplated joint efforts to be both possible and maybe even encouraged where it's needed?
So what Section 119.2 does is it allows the OPC to enter into agreements or arrangement with provinces to do a number of things. They can collaborate on research, they can collaborate on guidance, but more importantly, they can coordinate the activities. They can coordinate their activities to provide for mechanisms for the handling of any complaint in which they're mutually interested. So that's the part that authorizes joint investigations and allows them to collaborate on investigations quite consequently. And by the way, they already do that. So this is a continuation of what the OPC is already able to do, and this wouldn't change under the CPPA in any manner.
Thank you for that. That's very helpful. So that, I think, could reassure folks that may be skeptical about the OPC being able to collaborate effectively on joint investigations or other activities that are within his or her purview. The other thing that strikes me is, one of the things that it's hard to compare is how long an appeal would take through the court system, and how much more costly would it be versus going through the administrative tribunal route. And I think that, when Mr. Williams said, I can't remember how many times he said it in his original opening remarks, he said, justice delayed is justice denied. And I was thinking the whole time, and still, to this very moment, I'm thinking, wow, we're really hearing very clearly that the tribunal is not going to delay justice. What's going to delay justice is not having a tribunal, because the tribunal is going to speed up the process and remove and compress the timeline, perhaps. So, but how do we know that? That's what I'm sort of looking for, is, do we have any evidence and documentation of that could be submitted to the committee? I know it would be hard to do a comparison, because you wouldn't take both routes, perhaps, but maybe there's some way to show and reassure folks that are skeptical about that, because I think we've heard quite a few arguments that members opposite think that this is going to delay justice, that this is going to be more bureaucratic, that it's going to add a layer that's unneeded. And I think having any additional evidence and data on that would be very helpful. Is there anything that you could provide to further substantiate the fact that the tribunal will actually make things more effective and speed things up and make them less costly?
Sure, happy to respond. Thanks for the question. Our understanding is that at the moment, it takes 2 years on average for a case to reach the very first court, to reach the federal court. Beyond that, as I'm sure many of the members of the committee are familiar, it can take many, many years beyond that to go through the follow-on approaches of Federal Court of Appeal and then to the Supreme Court. I also think perhaps I'll take a moment to draw a bit of a contrast to the Competition Tribunal, because I know it's been raised in this committee in recent days as making an analogy or a comparison between the speed or efficacy of one tribunal versus another. Again, notwithstanding the fact that they would both be administrative tribunals in nature, the Commissioner of Competition and the Competition Bureau have quite different approaches and powers than those that are being contemplated here under the CPPA. The Competition Bureau has no power to issue orders or administer monetary penalties, whereas the OPC under CPPA would have the power to issue orders without going to the tribunal and to recommend administrative monetary penalties. The Competition Tribunal conducts first instance adjudication and imposes those orders and AMs. By contrast, the Personal Information and Data Protection Tribunal would hear appeals against the OPC's findings and compliance orders and decisions. It's a very different approach. The Competition Tribunal shows no deference to the Competition Bureau, whereas the tribunal, in this instance, must apply a deferential standard. So appreciating that some committee members have raised concerns about efficacy or approaches in comparisons to other existing tribunals, I just wanted to put that on the table, that this is in fact structured to be quite different in its approach. And Ms. Angus will add a little bit.
And I just wanted to add perhaps some more context. So in the case of the Social Security Tribunal, which is a tribunal that is supported by the Administrative Tribunal Support Services system that would we have also contemplated would support the tribunal contemplated under Bill C-27. Again, compared to the 2 years that the OPC is currently facing, the Social Security Tribunal, for example, hears cases in 2021 to 2022 heard it in 43 days. So there is a very substantial difference between the timing the time in which a tribunal, a specialized tribunal, can hear a case as opposed to the courts. And that's something that, as I mentioned earlier, the courts themselves have recognized.
So what I hear from that is not all tribunals are created equal, in a sense that they're different, and that some of them can move faster than others. What assurances can we have that the tribunal that's contemplated in this particular legislation would be faster than that 2-year appeal process in a federal court? Obviously, if cases went beyond that, which they wouldn't necessarily have to, then it would take many more years. But is there a, I don't know, an estimated timeline? I imagine it's probably hard to say at this point, because it doesn't exist. You'd want to stand it up and have it function for a while to get a sense probably of how long things would take to get through the tribunal. But do we have any way of knowing whether the tribunal contemplated in this case would be, much less time than 2 years on the average case?
Sure. Thanks again for the question. I think Ms. Angus, in fact, provided probably the best estimator available, which is to look at how quickly other tribunals are able to get to cases as a way of estimating how this one would operate. You're thinking about a dedicated group of resources with expertise in the issues who are able to be deployed to cases rapidly. Now, of course, it depends how many cases are being brought forward to the tribunal, how active the privacy commissioner may be with the new powers granted. So it's very difficult to estimate what the caseload overall would be. But the approach that's been taken here is meant to ensure efficiency in at least a couple of ways. One, to have a dedicated group of experts who grow their expertise over time in dealing with these cases, so they're able to move through them much more quickly and efficiently. Also, to avoid follow-on levels of appeal, which is a very, very significant difference because their decisions can only be judicially reviewed. That eliminates many, many years potentially from a follow-on process. And in so doing, I think offers a much more robust and yet efficient approach. Yeah.
Okay, thanks. And the other so appreciate that. So it sounds like it's sort of maybe more along the lines of the Social Security Tribunal that you were mentioning, perhaps, and certainly those follow-on processes through the court system would certainly have a long, extended time period. So I understand that because the only recourse after the tribunal were to hear an appeal would be a judicial review, which is very different, I think, than the other path that we were discussing through the court system. So that's interesting. The other implication I heard in your testimony, and you can correct me if I'm wrong here, but I think what you were implying, and I just wanted to maybe get you to draw this point out a little bit further, which is that, if I understood you correctly, that because of the OPC's new powers, which are significant, like the monetary penalties, I think, that are being proposed in this legislation are, my understanding is they're really significant because of the power to form compliance agreements and others, that there is significant power that's being given to invested in the OPC as contemplated in this bill, and that provides all the more reason perhaps to have a tribunal, given the principles of natural justice, that having that investigative and adjudicative function in one office holder or one person, the OPC, would be perceived as too much of a concentration, perhaps, of power, that there's no balance or there's no check to that power. And I think that to me is what you said. I don't know, I'm putting it in my own words, but would you like to maybe just clarify whether that's actually what you meant to say and whether I'm misinterpreting or not? But I think that's what I heard you say, that, with the new invested powers in the OPC that are above and beyond what perhaps other commissioners have, that the significance of the penalties, etc., that those powers justify having a sort of a check and balance built into the system in order to ensure that natural justice can be preserved.
Thank you. I think that's a very accurate encapsulation of the testimony we've provided.
Okay, great. That's all for me. Thanks.
Thank you very much, Mr. Turnbull. I now have Mr. Van Bynen.
Thank you, Mr. Chair. I'm not a lawyer, so I probably need some things clarified. That's probably a good thing. Yeah, that's a good, okay. But I've had some experiences with tribunals, particularly in my 12 years as being a municipal mayor. And actually, I'm of the view that these tribunals happen to expedite the situation. It allows us to develop expertise, as we've heard over and over again, and I've seen them work effectively, particularly in the province of Ontario. I have some concerns around the uneven playing field that we're looking at in the absence of a tribunal. So if we take a look at an issue going to the privacy commissioner, I guess my first question is what does that cost? What does that cost? Because my vision of an infringement on privacy is likely going to be the big guys with the big platforms versus someone who's had their issues or has had their privacy violated. So I see right from the very beginning, there's an unequal playing field in terms of resources and dollars. So what do you see as the initial stages? What I saw with the municipal board is if residents had an issue, they could attend at the municipal board and not have to engage legal counsel. And they could be heard. The council would hear what they have to say. Firstly, the municipal board would then overhear what their issues are. So let's start from stage one. If someone has an issue with Meta, what do they do and what's it going to cost them approximately?
Thank you very much for the question. So if somebody has an issue with Meta, the first thing that they can do is send a complaint to the Office of the Privacy Commissioner, and that costs nothing. You can do it online. The Privacy Commissioner can look at that complaint and can engage or seek a resolution of that complaint through alternative dispute mechanisms, so conciliation, mediation. And just to be clear, those are very flexible mechanisms that allow parties to agree on a resolution that can include damages, for example. So, that can be resolved right there. And in fact, the OPC does resolve 70% of the complaints that it receives at a very early stage of the process. If that's not possible, the Privacy Commissioner can undertake an investigation and has very broad powers with respect to its investigative powers. It can compel, it can ask for documents, it can talk to witnesses, all the investigative powers that it needs to resolve the complaint. It can then proceed, because we've given the CPP, the Privacy Commissioner additional powers in the CPPA. If they want to go forward, they can then start an inquiry. The inquiry allows the OPC to provide some sort of procedural guarantees to parties. So they would have to listen to all the parties involved, but they could conduct those hearings in private. So it's not like a court, it's not like a tribunal. They can conduct the hearings in private. And then at the end of the inquiry, they would issue a finding of whether there was a contravention of the act or not. And then in addition to that finding, they could issue a compliance order asking Meta, in this case, or any other company, to do something or to not do something in order to resolve the solution. And it is only if that company decides not to. And actually, before I get there, there's also the other avenue for the OPC, which is to enter into a compliance agreement. So this is a voluntary agreement. So the company would have to agree to enter into that agreement. And there are government amendments that allow financial consideration to be part of that agreement as well. So that could cover, that could sort of be a substitute for AMPS, but it could also cover damages. So that's another avenue. But if that avenue fails and the company doesn't want to undertake the compliance order or make changes based on the OPC's findings, that is when a company can appeal that finding to a tribunal. So it's very much appeal. The OPC in the first instance has the power to ask the company to do something or to not do something. It is only if the company does not agree with that they have a mechanism to dispute those findings, and that's the role that the tribunal plays. The OPC can also recommend AMPS in that case, depending on the findings, and it is the tribunal that will set those administrative monetary penalties. And typically, in most cases, it will end there because a decision from a tribunal is final. The tribunal has all the powers of a superior court, and it's final. It's only if there's some allegation that the tribunal did not act within its mandate that you could seek a judicial review from a court, which in most cases will not be the case because the tribunal will be supported by, as I've said before, the Administrative Tribunal Support Services, which is an organization that supports tribunals in achieving their mandate, and therefore ensures some of the independence and procedural safeguards that we've talked about. So it's really a closed system, and it really will have to go to judicial review in very exceptional cases where companies think that they've acted outside the powers attributed to them by the legislation.
So throughout all of this process, let's take a look at a group of people, Cambridge Analytica, for example, where a number of people who do not have resources would not have the financial wherewithal to challenge the actions of a larger group. So throughout all of this process, what would the person who's been offended have to pay?
So both the privacy commissioner and the tribunal don't have formal rules of procedure, so it makes it more accessible and easy. So you wouldn't have to, unless you wanted to engage counsel, you wouldn't have to pay anything to go through that process.
And part of the discussion that we're having here now is let's not have this tribunal. So then after the privacy commissioner investigates and sets out a fine or a fee, and Meta doesn't agree, then what happens if we don't have a tribunal?
Thanks for the question. I think that's a very interesting case in point, because I think it's something that we've contemplated through our own analysis. And our assessment of that scenario is that the case would then get referred to federal court, then onwards to the Court of Appeal, then potentially onward to the Supreme Court, depending on the facts of the case. Each layer would review the case de novo, which would lengthen the process. What that means is that somebody who was aggrieved or believed themselves to have suffered a contravention of the Act could wait many, many, many years for a satisfactory resolution of the case.
And you keep talking about de novo. So there's 3 levels of courts, right? And you mentioned that each case is a de novo case. Can you explain what that means?
The de novo is from the privacy commissioner to the federal court, which is the case right now. And what we mean by de novo is that because the privacy commissioner right now does not have any decision-making power, where the Bill C-27 contemplates that decision-making power, the court doesn't give any deference to the privacy commissioner's findings. It has to make its case like anyone else wouldn't have to make their case if they took a company or any other individual to court. And so there's no deference provided, and that's something that's changing under the C-27 the process we've contemplated in C-27, where the tribunal would have to provide deference to the commissioner on questions of fact and mixed fact and law. So that's what the de novo is. It really provides. It's really the court substituting its own analysis for the privacy commissioner's analysis.
You mentioned the term deference. What does that mean?
Deference means what that means is that it's a standard of review. So it's how much. I'm trying to explain it. Sorry. So the difference would just be how much you're relying on the commissioner's findings, and what sections 103 section 2 of CPPA contemplates is that on questions of fact and on questions of mixed fact and law, it is really the tribunal has to go with what the commissioner said about it, unless there's some compelling reason not to. So in all cases, or in most cases, that means that whatever the commissioner found in terms of its findings of fact is final, unless so it's a very high bar to overturn the commissioner's findings, which would not be the case in a court proceeding.
There's
So
another
the
point I'd like
ultimate-
to make about the
Go ahead.
deference piece as well that's really important to recognize. In a situation where the privacy commissioner is faced with a de novo proceeding at a court, the amount of time, resources, and effort required on the part of the commissioner to litigate that single case would be absolutely significant. Over time, what we expect would happen is that this would start to detract from the ability of the commissioner to have the appropriate resources to dedicate to new investigations, new work, new engagement, new advocacy functions, because more and more of it would get tied up in working through the litigation process. Some of these cases could take several years, depending on how many levels of court a case goes to. Not only does it slow down access to justice for the original complainants, not only does it slow down the system in terms of tying up court time, it also ties up the commissioner's time significantly. And that means that there is less resources available to focus on investigations and challenges that are appearing out there in the market.
I understand the process better now after those explanations, but I'm concerned about fairness. So we talked about deference and de novo. So if you go into the courts, then this is a de novo review or hearing. So does that mean that the issues and the principles and the facts can all be challenged and started all over again? And does that put Joe Average person who's been offended at a disadvantage because he has to face a whole new review, a whole new consideration, and a whole new offense to be determined? Is that?
That is absolutely correct.
So the fairness isn't there in terms of an unequal playing field as far as resources go? If in fact we're concerned about the average person that might have a violation by some of these large players. Okay, thank you. Those are my questions, Mr. Chair. Thank you.
Merci beaucoup, Monsieur Van Bynen. Monsieur Badaway. la parole.
Thank you, Mr. Van Byn. Mr. Badaway, over to you.
Although new on this committee, it was a quick process of learning throughout the last couple of days and all the materials you've been going through. And with that, understanding where we're at right now is simply a comparison between the tribunal and the courts. And with that said, I'm hearing, and please correct me if I'm wrong when I do pose the question, that the decision by a tribunal is in fact final. There's no appeal to the courts. But having said that, in the process, there is an opportunity to have mechanisms to ensure that the appellant is able to have their day with respect to some of the things that they're trying to accomplish. And what I mean by that is that there are mechanisms such as mediation before the process unfolds with respect to what the tribunal has to deliberate versus a court. A court would be more like an arbitration where there's no mechanisms in place to mediate. It's just simply a decision that's made, and of course, that's final. So with that, we've heard that a court of law is more costly to the appellant. We've heard that it's more time. It could be a lot more time, years. We heard that the experience on the issues is more apparent with a tribunal versus a court. We've heard that procedural fairness with respect to a tribunal versus a court, again, is apparent. I guess one of the questions I'm going to have, or I'll pose it now, is that in a tribunal versus a court of law, can it actually be dragged on even further over and above the process by, I'll use the word, the defendant at a court? Can it be dragged on and dragged on and dragged on over time, especially if it's an AI, and just be in there for years, if not decades, based on the wishes of one of the parties?
Thank you very much for the question. As my colleague Ms. Angus pointed out earlier, the rules of procedure would be quite different in a case of a tribunal versus a court. It means it's less likely to be susceptible to be gamed. It's also taking a much narrower perspective on the issue and focusing only on the appeal, the commissioner's decision in a manner that gives deference to the commissioner in the OPC. And so what that means is it's looking at a narrower set of issues, is not procedurally constrained the way a court may be, which means it's less subject to being gamed. And
I'm having a hard time hearing.
Yeah, you're right, Mr. Badaway. Colleagues, I hear a lot of chatter around the room. If you can please keep it down, Mr. Badaway.
Thank you, Mr. Chairman.
Thank you for that. As I was pointing out, because of the differences in rules of procedure and because of the differences in the deference offered, tribunal proceedings themselves would be expected to be much more efficient and quick, not even considering the fact that you'd then have a final decision which could not be further appealed. So there are multiple ways in which this process would be more efficient and speedier to reach a conclusion, and also more accessible.
Thank you. And I am impressing upon the business of government being more efficient and, of course, most importantly, most customer-friendly when appellants do have these appeals. And again, a tribunal versus the courts. I guess where I'm going to jump to now with respect to the Privacy Commissioner, and we heard that the Privacy Commissioner, to some extent, has an ombudsman-type role and advocates. And with that, I think what's more important while they're advocating is to navigate and to have those mechanisms available to them while they're trying to navigate based on what they're advocating. And with that, again, in the best interests of the appellant, and I'm hearing the tribunal versus the courts is more beneficial, especially, and I want to go back to this, with the ability while you're navigating to look at the opportunity to mediate and therefore come to some consensus, again, in fairness. So with that said, and going to the opinions of the privacy commissioners, some colleagues in the committee have cited the opinions of the privacy commissioners on the tribunal, including the Alberta Privacy Commissioner. In your previous testimony, you mentioned that there are key differences in the powers and responsibilities of the federal office of the Privacy Commissioner under the CPPA compared to Provincial Commissioner. Can you highlight those differences and why they make having a tribunal so important? And I really want to emphasize the fairness for the appellant at the tribunal level versus the courts.
Thank you for the question. Again, an important question. Alberta and British Columbia, to take two examples, don't have the ability to levy administrative monetary penalties. Quebec, in fact, does, but has an internal model that operates as a tribunal within the CIE. Those are really important differences in the way that the processes function. So while there may not be the need for a tribunal in some instances, if the desire of Parliament is to put in place a strong regulator with strong enforcement powers, that's what triggers the need to have the procedural fairness and impartiality of process baked into the process as well. So it really comes down to a choice about what is the policy objective that Parliament is trying to achieve. If it's to imbue a strong regulator with enforcement powers, the ability to levy administrative monetary penalties up to $10 million as contemplated in the bill, it needs to have that concordant procedural fairness aspect to it. Alberta and British Columbia also do not have the ability to enter into compliance agreements, whereas CPPA contemplates a range of tools that are available to the commissioner to bring cases to ground, either through mediation or arbitration, through negotiation directly with the complainant and the company in question, to be able to develop a robust compliance agreement that includes both behavioral or process changes as well as penalties and as well as contemplating damages for those who've been suffered from the contravention of the Act. There's a very powerful set of tools that we're putting before the Commissioner, and providing that also means providing a clear mechanism for recourse and ensuring that impartiality and due process are respected throughout that process.
That's a good point, impartiality and due process. And with that said, and I go back to, and I'm going to keep going back to this, is the opportunity to mediate versus to arbitrate. And that's, in my view, the difference between a tribunal and a court of law. The opportunity to mediate versus arbitrate. With that and the expertise, there seems to be some confusion amongst colleagues in the committee about the development of expertise that the tribunal represents. And there's a great comparison to that between, again, the tribunal versus the court of law in terms of expertise. Can you talk about why the tribunal will shorten the learning curve of dealing with privacy cases in Canada on account of the experts that are required to make up the body? That's point one. Point two is you can delve into the lack of expertise if, in fact, it goes directly to a court of law. And, of course, the repercussions because of that.
Thanks for the question. So there's actually two important ways in which we believe the expertise of the tribunal would function in this instance. The first is, as we previously pointed out, at least 3 of the members need to be appointed with previous expertise and experience in privacy and information law. The second and really critical piece is that by forming a dedicated body that would hear all of the cases coming through the CPPA, they would quickly develop expertise and understanding and efficiencies in recognizing certain points of fact, recognizing common patterns or issues that are emerging across a number of different domains. And in that way, they would be much better equipped to assess and respond to the Commissioner's findings and recommendations as compared to a general court, which would not have at its base expert members who are focused in privacy and information law, and would not necessarily be seeing multiple cases in the same domain, and would therefore not be able to develop over time that degree of expertise and familiarity and comfort with the issues. This becomes particularly important in a domain like privacy and information, where we're, for the most part, talking about highly technical issues which change rapidly based on the changing technology and the changing utilization of data. And it again reinforces the importance of having expertise and a degree of focus and dedication on the issue.
So, and I'm really relying on again, as you mentioned earlier, the policy objectives. And you know, what comes directly to front of mind is fairness. And with that said, is the range of tools and the enforcement powers and strong powers that a tribunal would have to actually offer the process with respect to fairness and meeting those outcomes. Less cost, less time for the appellant, not having the ability of the, I'll use the words other side, to drag on over time based on their interests, which we see in the court of law often. But again, I want to go back to what I said earlier about advocating, but more importantly, navigating in terms of what you're trying to, what your objectives are with respect to your advocating. And when you look at compliance agreements being negotiated, hopefully most times through mediation versus having it go the full field, that's appealing to me. And as a former mayor for 14 years, I had great experience in witnessing, from my municipal experience, a lot of tribunals in action, whether it be through the Planning Act, vis-a-vis then through the Drainage Act, with courts of revision and tribunals. When we look at the tenant board provincially, and we look at their adjudication process, and the lists go on, and how, again, I'll go back to that word again, fairness, how it actually, with respect to the objectives, provided that navigation based on the advocation of fairness. And when we look at the alternative dispute mechanisms that are available in comparison to a court of law, once again, it really offers that ability for a fair process for the appellant. And, you know, Lord knows, in some of the cases on who they're up against, they're going to need that fairness. Because let's face it, sometimes it's a David and Goliath situation. And we're already seeing that in some cases, especially with what we're discussing today. So with respect to that comment, I think we all agree that there needs to be a system to review decisions made by the Privacy Commissioner. But there may be some hesitation around the table about why it has to be in the form of a tribunal versus a court. So I want to go back to that. And I believe the intention was to support Canadians and small businesses without extensive legal resources, cost, time, everything I've mentioned already. Is that so? And with that, what are some of the other ideas, thoughts that we can have that can be added to this conversation?
Sure. I think it's an important issue to unpack a little bit. I think part of the rationale here is to understand that having an expert tribunal focused on the issues dedicated to this work does offer many benefits to the administration of justice and to ensuring that the law is effectively and consistently applied. It also makes sure that the commissioner and the OPC are central in both the fact-finding and the investigation. The role of the OPC becomes strengthened by having an expert tribunal available to hear the appeals. In a situation where a tribunal gives deference to the Privacy Commissioner, that is a much more robust and powerful hand for the Privacy Commissioner to play, even if the case does not go to the tribunal at the end of the day. What I mean by that is it actually motivates parties to work with the Commissioner to resolve their cases, because they recognize that if they choose to take it to the tribunal, they would be doing so on the basis of playing a weaker hand in front of that tribunal because of the deference that the tribunal must show to the Commissioner. That is not the case with the courts. And we've seen that over the last 20 years. There's been a number of cases that have gone to the courts, and the Privacy Commissioner has lost 70% of the cases in which he or she was a primary appellant in that case. 70% of the time, the Privacy Commissioner's findings or administrative monetary penalty recommendations have been overturned.
Again, and I guess this is somewhat becoming the narrative of my questioning, is the fairness. And that's the bottom line, in my view, in my opinion. It is fairness. Less cost, less time, the possibility for mediation. When we look at, compared to the courts, more cost, more time, and to some extent, depending on who the Goliath may be, a lot more time, possibly decades. Are we actually meeting our objective? Are we then actually meeting the outcomes that we would otherwise expect to come out of the process? And finally, is the ability to then lend itself to other issues that may arise within the same sector, the same realm, if you know what I mean. Because, and I guess I can pose this in the form of a question, would then decisions made by a tribunal be considered part of case law in terms of other situations that might arise that can then lend itself to expediting or mediating other issues that might come to the Privacy Commissioner and or possibly the tribunal and or a court of law?
Yep, thanks for the question. It's a good one. It would form the corpus of decisions that would inform the OPC, and it would inform the interpretation and application of the CPPA. So within the internal world of the Consumer Privacy Protection Act, each decision of the tribunal would have an effect of setting a precedent and work for within the CPPA. It would not affect kind of the more broader court system, but it would really be functional for the CPPA, which is, I think, what is intended.
The outcome here that we want to come to is with respect to privacy. And we can see what's out there right now. And we can see the effects of what's out there right now on people. Because the second narrative that I'm leaning now toward is people. And it's about the effects on people. And it's about having fairness to deal with some of the effects on people. And if that's the outcome that we're all looking for, which I would expect it would be as members of parliament, regardless of what party we may belong to, the outcome is to ensure that these are dealt with in a timely and fair manner. In your opinion, as the person that the people that know a heck of a lot more than we do in this realm, what is the bottom line in terms of meeting those outcomes between a tribunal and a court of law?
Thanks for the question. I think thanks for the question. I think our testimony over the last several meetings has been very clear, but I'm happy to recap. We see there being significant efficiency gains by implementing a tribunal. It's absolutely fundamentally important in order to maintain alignment with the Constitution to have procedural fairness and due process built into the system. Doing so via tribunal is the most efficient and effective way to do so. We've thought very carefully about how to make sure that it does not become an additional layer of review, for example, by ensuring that the tribunal gives deference to the commissioner's findings and decisions, and by ensuring that it's a final level of review and is not subject to appeal. And so there are many ways in which this has been designed carefully to ensure that the important objectives of procedural fairness and of efficiency and effectiveness and access to justice are appropriately centered, and to ensure that in so doing, the role of the Privacy Commissioner remains primary and cannot be subverted by a large corporation that's able to drag out court proceedings and drain the Privacy Commissioner of the resources and time needed to effectively steward consumer and Canadians' privacy through the markets.
And I appreciate that. I only had to hear it once, and I appreciate repeating it so some of the members can hear it a few more times, and hopefully that'll make a difference. Because again, I want to go back to what I said earlier. It's the outcomes that we're actually trying to accomplish here. And again, it goes back to dealing with fairness, and that being fairness to people who, to some extent, for the most part, especially in some of these situations, are very hurt by some of the situations that they're finding themselves in, especially some of the youngsters and those that are experiencing some of these situations that would otherwise find themselves in a tribunal and or in a comparison, a court of law. So I guess my last question is going to be, when discussing tribunals, we've referenced other international jurisdictions. And I know I've heard this already in terms of you referring to it, but again, I do want to be repetitive, and I do not apologize for that, because some do need to hear it maybe more than once. But when discussing tribunals, we've referenced other international jurisdictions which do not have, which do have privacy tribunals. And we've talked a lot about comparisons with the Competition Bureau, but are there other examples throughout governments, possibly? How were those models used to inform this tribunal? And what benefits have we seen with tribunals in other areas of federal regulation?
So we've discussed several international, but also domestic and other federal examples where tribunals are used. I'll start with domestic. The CAI, which is the privacy regulator in Quebec, is an administrative tribunal. So and it operates extremely efficiently, and is able to reach the outcomes that you outlined. Within the federal system, there are many examples of tribunal. The CRTC, the Canadian Radio, Television and Telecommunications Commission, which is responsible for administrating the Broadcasting Act, the Telecommunications Act, and Canada's anti-spam legislation, so not trivial issues, is also an administrative tribunal that's very highly respected. I spoke earlier as well about the Administrative Tribunal Support Services Institution that provides administrative services to tribunals. It supports 12 federal tribunals that include the Competition Tribunal, and as well the Social Security Tribunal, as I mentioned earlier. And we've seen that it cuts time in terms of access to justice and getting to the outcomes as quickly as possible. Right now, the OPC faces a 2-year delay in getting to court, and in the Social Security Tribunal, it's less than 100 days. It can be 43 days. So there are significant benefits in terms of getting to the outcomes faster in a more cheaper way, because tribunals typically don't have the same formal rules as a court, which allows parties to not retain legal counsel, because the more formal and procedural a setting is, the more need for legal counsel. So it really allows parties to access justice in a way that's cheaper and in a way that's faster.
Those words, fairness and people. Underline, bold it. Fairness and people. Fairness and people. And with respect to accessing justice and to be fair to the people, not everyone can afford the processes of a court, especially if they're against a Goliath, especially if that ends up in the court for decades against that Goliath. We can be talking hundreds of thousands, if not millions of dollars to a person that just doesn't have it. And therefore, no fairness for the people. More cost based on more time. Versus a tribunal, which offers that fairness, and it offers, based on the cost, less time, therefore less cost. Is that fair to say?
I think that's fair. I think it also offers an additional feature, which we've referenced a few times, which is that it centers the role of the Privacy Commissioner. It gives the Privacy Commissioner more authority, more weight. As I pointed out earlier, if a company knows that they can go and get a fresh start with a court and impugn the commissioner's approach or impartiality with which it was conducted, that certainly creates a challenge, whereas the tribunal has to give deference to the commissioner's findings. That makes the commissioner far more powerful.
I guess, Mr. Chairman, I'll end up by saying this. Again, being new to the committee and taking all this in within the last few days, I want to thank you. I want to thank the committee, quite frankly, but as well all the witnesses. And the take that I come away with and walk away with, based on what I'm seeing, what I'm hearing, is those 2 points. Is that fairness for the people, and I think the tribunal does meet that outcome that we're trying to achieve here, as well as the expectations that we're trying to come to on behalf of the people that we represent. Thank you.
Thank you, MP Badaway. I'll now turn it over to Mr. Perkins.
Thank you, Mr. Chair. The comment about the CRTC being comparable to me, is erroneous, because there is no body making a decision before that then gets appealed to the CRTC. It's a single issue commission making a decision. So it's actually more relative to what we're proposing than what officials are proposing. But what's interesting, and I'm not surprised that the officials who drafted the bill are defending the bill, and for the new members, the 2 new members on the committee who perhaps didn't attend the 21 meetings of witnesses and the 10 meetings here, we've now had six meetings over 2 clauses, where the Liberals have filled the air on 2 clauses. But I'll take my guidance from the current and former privacy commissioner on this issue. So just to help you, because you haven't heard the testimony, I'll read what they said. There was a bill that was essentially identical to this with regard to privacy in the tribunal in the last parliament called C11. And the privacy commissioner then, in his submission, said, in our opinion, the design of the decision-making system proposed in the CPPA goes in the wrong direction. By adding an administrative appeals tribunal and reserving the power to impose monetary penalties at that level, the CPPA encourages organizations to use the appeal process rather than seek common ground with the OPC when it's about to render an unfavorable decision. While the drafters of the legislation wanted to have informal resolution of cases, they removed an important persuasive tool. Now, that was in the last bill. Just to refresh your memory from what the privacy commissioner said in his testimony on this bill in meeting 91, October 19th. Third, there remains the proposed addition of a new tribunal, which would become a fourth layer of review in the complaints process. As indicated in our submission to the committee, this would make the process longer, just from MP Badaway, who thinks it would make it shorter. The privacy commissioner thinks it would make it longer, and by the way, more expensive. So if you care about fairness and you care about the people and you want it less expensive and quicker, I would rely on the privacy commissioner's testimony for fairness and people, who he says this process will actually make it longer and more expensive. Now, not to be outdone, I'll just give you a little more in meeting number 92, what the former privacy commissioner said. The goal of these provisions should be quick and effective remedies for the citizens. In no other jurisdiction that I know of is there a tribunal such as that proposed in this legislation. In all other privacy jurisdictions, the original decision maker, including with the power to make orders and set fines, is the Data Protection Authority that is equivalent to the Office of the Privacy Commissioner. I have concerns about the difficulty for the OPC to work in these different roles. So we have an issue here with the government continuing to put the proposition out that somehow creating a privacy tribunal speeds it up, when that's not actually what the experts say that I would rely on, the privacy commissioner. I would also say that in the case of the competition tribunal, which is probably the most comparable to this, where you have a competition bureau which does an investigation and a competition tribunal that doesn't have to follow evidentiary rules and only has two minor things that you can appeal it. So almost, but not quite, final decision-making process. It actually makes for a very long process, a very expensive process, and has actually never actually rejected anything that's been done in a merger. So I'm just trying to help our new members understand that if they believe this makes it quicker and faster, the testimony we heard from privacy commissioners, both provincial and federal, over 21 meetings of witnesses, says the opposite. That's all I wanted to say.
So I understand that was not a question, but a comment. Thank you, Mr. Perkins. I have MP Area.
Thank you, Mr. Chair. I have a question for Mr. Chabra. Mr. Chabra, you rightly pointed out presence of a tribunal or availability of the process of using a tribunal. It motivates the parties to seek some sort of agreeable outcome at the commissioner's level. That is very important, especially given the background that, before I go to that, you mentioned the behavioral process change. Was this what you were referring to when you mentioned that?
Thank you for the question. Yeah, it's a really important point to raise, that the tribunal has to give deference, and therefore this notion that somehow companies would be motivated to go to the tribunal more so than they'd be motivated to go to a court if you were to substitute a general court instead of the tribunal, it doesn't hold up under scrutiny. The notion that a company would be more motivated to go to a tribunal that they know is going to give deference to the commissioner's findings of fact, it just doesn't hold up.
And especially with the fact that 70% of the cases which the Privacy Commissioner's rulings were challenged in the court, the Privacy Commissioner lost. So this is the unique feature. I don't think other countries, most G7 countries, they don't have a tribunal, but with the changing circumstances, I think Canada has to take the lead. Am I correct on that compared to the other G7 countries?
Well, as we've pointed out throughout our testimony, excuse me, over the last several days, there are a number of other countries, G7 countries, that do have tribunals or tribunal-like approaches that help to separate the investigatory and adjudicative functions. Australia, New Zealand, Singapore, UK with a slightly different wrinkle. Ireland is very comparable as well. This notion of separating investigation and adjudication is a bedrock principle of functioning democracies.
With respect to the US, where they have that Federal Trade Commission, it's a one big, huge bureaucracy. They don't have a tribunal, but they've got a very complex process of handling these things, correct?
So the Federal Trade Commission doesn't operate in the space of privacy and data protection. It's also a commission by design, which means it's not a single individual that's taking a decision. And again, so the procedural fairness considerations there are baked into the fact that it's a commission or a group of people taking decisions. Yeah.
And you did mention about the expertise that the members who are appointed on the tribunal will not only have good background and expertise in this knowledge, they can continue to upgrade their knowledge in this. They can become much more specialized. I remember when I was debating this bill in the parliament, a question was asked, and I was explaining that the technologies are so much changing, we can't even define what data is, what are the contours of data, and the technologies like artificial intelligence, we can't even define what artificial intelligence is. And when it comes to privacy, based on all these things, it will become very, very difficult for the courts to decide. The courts have to limit themselves to the law, and they will not be able to get themselves, the judge or whosoever decides cannot get that expertise or the additional knowledge that is required with the changing circumstances, changing technology. So how much do you think workload you expect when the tribunal is formed in the first 2 years?
Thanks for the question. As we noted earlier, it's somewhat difficult to give a point estimate or even a range estimate, frankly, on how much activity such a tribunal would see. There's a number of factors to consider. The fact that the commissioner would have significant new powers, but also significant new opportunities to navigate through an individual case, through taking a mediation approach, through taking a compliance agreement approach. If the commissioner, for example, were to work through a case and find that making orders was sufficient, the case wouldn't necessarily need to go to the tribunal at all. So difficult to give an estimate of exactly how many cases would be taken. We can look back and say that there have been about 46 cases from memory between 2003 and 2024 that went to court on the basis of a privacy commissioner finding. But that's a different set of circumstances where the commissioner does not have the ability to levy or recommend administrative monetary penalties, where the commissioner does not have order-making powers. We are talking about very much a completely new approach to providing the commissioner with significant enforcement powers. How much activity that would generate for the tribunal, difficult to say, but we are very confident in presenting the committee with the idea that it would be more efficient to have a tribunal in place, that it would be more rapid, and that it would be more expert in its work.
In general, you will see the increase in compared to the previous number of things that went to court?
I think given the new powers being vested with the commissioner and the increasing ubiquity with which data and privacy issues are important for Canadians, including because of the rising use of AI tools, I think it would be reasonable to assume that there would be more activity going forward. and that there may well be more demand for either court or a tribunal to be engaged on those decisions.
So, as you said, that there's a possibility of more workload. So it does make the privacy commissioners work efficient, because if without the tribunal, all these cases will go to the court, and the time required to get dealt with the resources required will be quite substantial.
Yeah, thank you again for the question. I think this is a really important issue to underline, noting that some previous witnesses have highlighted that they feel like the tribunal could add process and time. It's not entirely clear to me whether all the witnesses had the opportunity to be fully briefed on the functioning of the proposed bill, particularly the idea that the two elements in particular, that the tribunal would require to provide deference to the commissioner's findings, and second, that the decisions could not be appealed. Those two pieces in concert provide a significant backstop against abusive process, against processes being unduly extended, against multiple levels of appeal. And as I pointed out earlier, it really centers and puts the spotlight on the privacy commissioner, because I cannot imagine a scenario in which any company with reasonable amount of legal advice would rather go to a tribunal that has to pay deference to the commissioner versus this other approach, which apparently is going to a court and starting de novo. Any lawyer worth their salt would have to advise a company to say, well, you'd rather take your chances starting fresh at court and see if you can convince the court to see it differently, versus, oh, you've got a tribunal in place that's going to pay deference to the commissioner's findings. Boy, your chances are a lot lower in that circumstance. So this notion that's come up a few times in the committee that somehow the tribunal kind of slows things down and companies will be more motivated to go to the tribunal and less motivated to work with the privacy commissioner, I would have to say that represents a significant misunderstanding of the functioning of the bill.
I agree with you on the point. Have you have you looked at any scenarios, like how much of the ones that are settled or that are dealt at the tribunal level will go to the court?
Yeah, so as we mentioned earlier, when we looked at the last roughly 20 years of cases that have gone to court, about 46, I think it was, decisions from the commissioner have been taken to court. In a minority of those, the commissioner, him or herself, was actually a primary appellant. And in those cases, the commissioner lost 70% of the time before the courts. So that, I think, gives a very, very clear demonstration of why companies might be motivated to go to court. They have a pretty good chance of winning. And so again, it's a pretty stark contrast between going to a court and doing a de novo proceeding, where the history has shown that courts tend to side with the companies, and versus having a tribunal that's got to give deference to the commissioner. That changes the playing field entirely.
Can you give any example of any of the court cases that has gone previously to the court and which took quite a long time to get settled?
I can talk about a very recent case. So recently, or a few years ago actually, the OPC made a finding with respect to Meta and the Cambridge Analytica scandal. And the commissioner issued its report of findings a few years ago. Meta disagreed with those findings and took the OPC to court on those. And the OPC actually lost at federal court. So the federal court sided with Meta to say the OPC actually had not discharged its investigative burden, had not presented its evidence. Now, I'll just make a connection here to what my colleague said. Again, because they're not showing any deference to the privacy commissioner, it's a de novo proceeding. This would not be the case with a tribunal, which would have to accept the commissioner's finding of fact unless there was a palpable error. And that decision was appealed by the privacy commissioner last summer, and we're still waiting for a decision from the Federal Court of Appeal. And I think we can assume that decision would be appealed to the Supreme Court as well, because of the parties involved. So it's going to take years to get to a final resolution. That would, again, not be the case in this new system where a tribunal's decisions are final and only can be judicially reviewed, which is a much narrow standard of review, which means much more difficult to make the case, and the parties would know that. And again, to echo my colleagues' comments, and therefore perhaps more motivated to pursue alternative dispute resolution mechanisms or compliance agreements.
Obviously, you're right. In Meta, Cambridge Analytica case, they have the muscle power to take it all to the Supreme Court. So the time taken there. If the same case was with the tribunal and the chances of it getting resolved will be much better, you think, than the current one?
In fact, that is the design of the system that's proposed by Bill C-27 and the CPPA. It is, in fact, to have the commissioner have a stronger hand at that appeal process by virtue of the fact that the tribunal has to defer to the commissioner's findings of fact and mix of findings of fact and law. That is an entirely different playing field than you'd find at court. And so in that way, it is very much designed to ensure both speed, but also to provide the commissioner with a significantly stronger hand than if he or she were to take a case to court. And of course, the fact that the finding itself of the tribunal, the fact that it can't be appealed, is another piece that creates a very significant backstop against a lengthy delay or overextended process.
Now, recently I was reading or listening something about the empires in the history of the world. In the recent history, we had the British Empire, we have got almost an American empire, but the future empires will be dominated, controlled by the technology companies who have got the strong muscle power, the cash power, and dealing with them requires new tools. They have we have seen the example with Meta is the very prime example. When dealing with those companies, the tribunals with the experts on the bench of the tribunals, they play a very important role. Chair, how much time
Yes,
do you have?
Mr. Area, we're out of time. This brings our meeting to an end. But before, I just want to thank Madame Angus, Mr. Chabra for joining us yet again. You've been with us for the whole month of May. And this is technically our last meeting on C27 for some time. We're at CPC 9, so I hope the summer will make us reflect on where we want to go with this bill. And so thank you very much for your professionalism and for your time. Et Monsieur Chan aussi qui est pas là aujourd'hui. Merci beaucoup. Oui, Mr. Chan aussi. Merci beaucoup.
And as
Now-
well as not with us yesterday. Yes, Mr. Shan, thank you. Turn.